We have the special treat of having our very own special agent, Tom Burleson, presenting on the U.S. criminal justice system. As many of you know, Tom, he is the director of the chorus here at River Landing. He lives outside in one of the cottages. His lovely wife Peggy is here with us in the audience. So we are excited to hear about his years of knowledge in the FBI and hear about all the crimes he solved. So he was the original crime fighter. So without further ado, Tom Burleson.
Thanks, Brian. I appreciate that very much. As Brian said, I was a special agent of the FBI for 26 years. Someone recently told me, one of our newer residents said that we had a lot of FIPs living at River Landing, and I asked what FIP was, and he said that's formally important people. So I may have been a formally important person, but I'd like to talk to you this afternoon for 45 minutes or so about the criminal justice system in the United States. And we're going to divide our conversation into two parts. The conversation that we're going to have today is going to be called From Hammurabi to the Constitution. And we're going to go back about 3,000 years or so, 3,500 years, to the beginning of codified laws, and that began with Hammurabi. Today, most of our conversation will be rather academic, so if you nod off in the middle of it with your long afternoon nap, that's going to be perfectly okay. But it's going to be academic, but I think it's important that we cover all of this because it gives the basis for the criminal justice system that we have in the United States today. And if we don't understand how we got here, we can't very well understand what we're doing today. And some of those principles of how we got here are just as important today, perhaps more important than they were at the time of their conception. I'd like to give you this overview from my perspective as being inside the system, as I said, for 26 years. The first thing we need to talk about is the Code of Hammurabi. And the Hammurabi Code was established by a man named Hammurabi, who was the king of Babylon back around 1750 or so. The kingdom of Babylon was quite large at that time and extended from what is now Iraq up to the northwest and covered a lot of territory. Hammurabi and his court had come up with a with a set of laws and set of statutes, and he had engraved these, had them engraved on on stone steles, they were called, or stelas, and these were about 7 or 8 feet tall, depending on where they were stationed, and they had engraved on them all of the laws of the kingdom of at that time. And so what did we learn from that? What did we get from that? Well, it began the concept of the rule of law. You hear that term a lot today, the rule of law. What does that mean? What is the rule of law? The rule of law simply means that we are governed by the law. We are not governed by the king or by the emperor, and that even the emperor or the king also has to abide by the rule of law, and it limits what the king can do as far as the subjects are concerned. The Hammurabi Code also started what was called the presumption of innocence, and that's a very important concept that is true even until today. If you are charged with a crime and you go into the United States District Court, you have an absolute presumption of innocence. The government must prove that you are guilty. You do not have to prove that you are innocent. And finally, with Hammurabi, a lot of historians believe that Hammurabi, the Hammurabi Code, may have been the source of the law of Moses, because the children of Israel, the Jews, were taken captive by the Babylonians during this period, and they learned a lot from the populations, from the nations that had taken them captive. For example, they developed their own written language as a result of being in Babylon during this period of time. Also, because this code was chiseled in stone, a lot of folks think that the story of Moses and the Ten Commandments being chiseled in stone was an outgrowth of that. But that's for you to decide and for a topic for a discussion for another day. Moving forward, we had Greek democracies that presented themselves. They also instituted an early concept of the rule of law. They had magistrates and juries that were drawn by lottery from the assembly, which was composed of all citizens. And that was a little bit unusual, that all citizens were involved instead of just a court or the king's court. All citizens had the right to bring both private and public matters before the courts, but its large juries were a common subject of mockery by critics at the time. Sometimes these juries could number as many as 5,000 people. The Athenian system appears to have worked pretty well, with the exception of some of those minor issues. You have to remember that the Athenian system, the Greek system, was an early democracy. It was not what we have today, which is a democratic republic. Moving even forward to the Romans now, the Roman law was less egalitarian than the Athenian law. And its purpose was to protect the aristocratic landowners of that day. The Roman tradition implanted several basic principles of the rule of law: the need for public knowledge of civil law and of judicial procedures, so everyone knew what to expect from the law, and that the law should be stable and evolve according to precedent and circumstance, not just be rooted and stay in one place. And that the natural law, the universal rights of man, a terribly important concept as we go forward, can provide the basis for positive law, for man-made law. And the Roman tradition was maintained under the Byzantine Empire and incorporated in much of the subsequent European expansion of the Roman Empire into France and into Western Europe and what is now England and Great Britain. An outgrowth of this Roman law was a document called the Magna Carta, or the Magna Charta, that was signed by King John on June 15th of 1215. The Magna Carta sets forth a tremendous amount of change in our understanding of jurisprudence and how the legal system should interact with the government. Some of the provisions were that no free man shall be seized or imprisoned or stripped of his rights or possessions or outlawed or exiled or deprived of his standing in any other way, nor will we, the king or his court, proceed with force against him or send others to do so, except by the lawful judgment of his equals or by the law of the land. Two important concepts here. One is it has to be a free man, not a vassal or a servant or a indentured servant or anything like that. The person had to be a citizen, and he was judged by his equals and not just by the king's court. The Magna Carta, like our Constitution, evolved over time. They started with a set of documents, but over time they added to the basic document, basic understanding. The Petition of Grievances was adopted in 1610 and established the right of citizens to petition the government to seek redress of abuses of power. We have that same thing in our Constitution under the First Amendment. We're going to talk about the Constitution a little bit later. Second, it established the right to a trial by jury. And the jury was a, quote, jury of one's peers. And it wasn't the 5,000-person jury. It was a smaller jury of varying sizes, from 6, even like today we have from 6 to 12 people on the jury. It also provided a prohibition against cruel or unusual punishment, just like we have today. There is a prohibition against cruel and unusual punishment in our Constitution. It also provided much later on in 1679 the Habeas Corpus Act, which simply means, habeas corpus translated means bring us the body or let us have the body. What that means is that you cannot be put in prison for an extended period of time without charges being brought against you, which means bring the body to court. We want to find out what this person is charged with. And so the Habeas Corpus Act gave defendants the right to be presented to a judge to determine if there was legitimate cause for arrest. We would today call that a predicate offense. And that's a word that you hear a lot today in relation to crimes that are alleged to have been committed by government officials. Predicate offense. A predicate offense is very important in our understanding of our legal system, so that people could not be held in secret, but they had to be brought forward and charged officially. We do that today. Moving on along, the Age of Enlightenment, or the Age of Reason, was very, very important in the development of our legal system. The Enlightenment period, as I said, also referred to as the Age of Enlightenment and Reason, stretched excuse me, from about 1685 to 1850. Now, this period is characterized by thinkers and philosophers throughout Europe and the United States who believed that humanity could be changed and improved through science and reason. The French Revolution and the American Revolution both occurred during this period and are arguably outgrowths of this age of enlightenment. The rights of man, which I talked about in a previous slide, is a very, very important item. It was a concept that was developed over thousands of years, from the Hammurabi Code all the way to the Magna Carta. The Age of Enlightenment and European philosophers of Locke and Voltaire and Rousseau, and the American Enlightenment period of the 17th and 18th centuries formed the basis of our Declaration of Independence and our Constitution. And some of those Enlightenment thinkers were Jefferson and Paine and Adams and Franklin and Washington and Hamilton and others. And an outgrowth of this was our Declaration of Independence. A lot of people think that the Declaration of Independence was signed and then we went to war with Great Britain. And that's backwards. The Revolutionary War actually began on April 19th, 1775 in the area of Boston at the Tea Party, and then when the British marched on the Green and there was the battles there on the Green. That's what started the Revolutionary War. But the Second Continental Congress, as you are aware, signed on July 4th, 1776 in Philadelphia, signed the Declaration of Independence over a year later than the war started. It set the United States of America on a new course. And notice I've underlined and italicized United States of America, because before then it was just the colonies. It was the American colonies. But now we have a country called the United States of America. And it provides the reasoning why it was necessary to separate from British rule. And it established a new nation based on the rights of man, as opposed to the power of the sovereign or the government. And in the Constitution, of course, we have those sacred words that we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. Those were terms that developed. We'd like to give Jefferson credit for that, but it probably came from some of the other enlightened thinkers in Europe. But still, it's a magnificent part of our Constitution and our nation. The Declaration of Independence is not a part of the Constitution of the United States. It is a separate document. After, just before the truce was signed with the British and the British surrender at Yorktown, about 3 months prior to that, in 1781, the Articles of Confederation were adopted and provided for a very loose confederation of U.S. states, which heretofore were sovereign in most of their affairs. What we had was 13 individual colonies. We really didn't have a country as such. So we needed to move forward in some way to establish a universal national government. On paper, the Congress, the central authority, had the power to govern foreign affairs, conduct war, and regulate currency. Congress was given no authority to enforce its requests for money or troops. And by 1786, it was apparent that the Union would soon break up if the Articles of Confederation were not amended or replaced. 5 states met in Annapolis, Maryland, and sent delegates to a new constitutional convention to be held in Philadelphia. 4 years, let's see. I want to go on. So an outgrowth of that was the Constitution of the United States, which was signed on September 17th, 1787. The new Constitution was signed and it was adopted by the convention. The ratification process for the Constitution began that same day and ended when the final state, Rhode Island, ratified it on May 29th, 1790. And that brought about the Constitution of the United States. And we've all seen this document. Me. The document that we have as a Constitution is a very, very important piece of writing for our country. It is the foundation of our country. I have a degree in history, and that's why I'm so interested in all these historical things that most people don't really care much about, but it's very, very important. And I also learned constitutional law at the FBI Academy when I was a new agent going through agent training school. And my constitutional law instructor was a man named Charles Donlin. And Mr. Donlin was a Harvard Law graduate, and he would show up for class in his Brooks Brothers suit and his finely starched button-down collar with a regimental tie and his Bostonian wingtip shoes. He was a brilliant man. He was probably in his 60s and was one of the FBI and Department of Justice true scholars when it came to the Constitution. And he was from Boston. He had a Boston accent. And he had the same group of characters in his stories that he would illustrate with. And the characters were Al Allhot, Special Agent of the FBI, and Tom Trueblood, Special Agent of the FBI. And the bad guys were always Axel McCluskey and Balzo Leary. And their attorney was somebody named Springham McCarty. And they were always robbing the Shamat National Bank in Boston, the hub of the universe, as Mr. Donlin would say. And he was a spectacular, brilliant man and was a marvelous teacher. So let's look at the Constitution. Slide. The Constitution of the United States is the supreme law of the United States of America. The Constitution delineates the national frame of the government. Its first 3 articles embody the doctrine of the separation of powers, whereby the federal government is divided into 3 branches: the legislative, consisting of the bicameral Congress, the executive, consisting of the president, and the judicial, consisting of the Supreme Court and other federal courts. Articles 4, 5, and 6 embody concepts of federalism, describing the rights and responsibilities of state governments and the states in relationship to the federal government, and the shared process of constitutional amendment. Article 7 establishes the procedure subsequently used by the 13 states to ratify it. It is regarded as the oldest written and codified national constitution in force today. It's important that we understand the structure of the federal government so that one branch of government doesn't impede or interfere with another, illegally with another branch of the government. The United States is a democratic republic. It is not a democracy. The federal government of the United States is composed of, as I said earlier, the executive branch, consisting of the president and his staff and the employees under them. In my case, it would be the attorney general, works for the executive branch, and I worked under the director of the FBI and the attorney general as part of the executive branch of the federal government. Then there's the legislative branch, a bicameral branch, which simply means that there's two houses, the Senate and the House of Representatives. Then there's the judicial branch that consists of the Supreme Court, the appellate courts, and the district courts. In modern republics, the rule of law relies on a judiciary or court system that can act independently of executive and legislative powers and thus rule on the basis of established law and precedent, not arbitrarily or politically motivated considerations. In describing the idea of the separation of powers, Baron de Montesquieu wrote in Spirit of Laws in 1748, "Again, there is no liberty if the power of judging be not separated from the legislative and executive powers. Were it joined with the legislature, the life and liberty of the subject would be exposed to arbitrary control, for the judge would be then the legislator. Were it joined to the executive power, the judge might behave with all the violence of an oppressor." So it is terribly important that we maintain an independent judiciary. And we have to understand what that means. The judiciary was established through the advise and consent powers of the Senate in approving presidential nominees for federal judges, and in the House and Senate's authority to impeach and remove judges from their lifetime appointments for reasons of incompetence or malfeasance. That's a very, very important paragraph, the concept of advise and consent. And it continues even today, particularly when there is a change in presidents, because presidents appoint their own staff, their own cabinets, they appoint judges, they appoint United States attorneys, and all of these people, or a lot of them, have to be approved under this advise and consent concept. The independence of the judiciary was further strengthened in a legal case called Marbury versus Madison in 1803. It was decided under Chief Justice John Marshall, which asserted the Supreme Court's power of judicial review, meaning that the court became the final arbiter of whether or not laws and the government's actions are constitutional. So the court is the final arbiter of what the other two branches of the government do in case there is a conflict between the two. The Constitution was written, and as I indicated earlier, has been amended over the years several times, and those amendments started with what we commonly call the Bill of Rights, or the first 10 amendments to the Constitution. And I'd like to read to you why the government felt it was necessary to do that from this paragraph before you now. The conventions of a number of states being, at the time of adopting the Constitution, expressed a desire in order to prevent misconstruction or abuse of its power, that further declaratory and restrictive clauses should be added, and as extending the ground of public confidence in the government will best ensure the beneficent ends of its institution. Resolved by the House and Senate of the United States of America and Congress, assembled, 2/3 of both houses concurring that the following articles be proposed to the legislatures of the several states as amendments to the Constitution of the United States, all or any of which articles, when ratified by 3/4 of the said legislatures, those would be state legislatures, to be valid to all the intents and purposes as part of the Constitution. It's very, very important that you understand two numbers in this paragraph. One is that the Congress, with 2/3 of both houses conferring, can bring an amendment of the Constitution, can change an article of the Constitution, but there must be 2/3 of both houses agreeing to do that. And then once the Congress agrees, the Congress or the House and the Senate agrees, it goes forward to the states. And all of the states must examine the proposed changes and then ratify it by 3/4 of the states. And so it's a long process, but that is how the Constitution is changed. The Constitution is not changed by somebody wanting things to be different than the understanding of the Constitution or the way the Constitution was written. If the people want the Constitution changed, there is a provision to change it. But it's not by activist judges or by politicians who don't agree with what's in the Constitution. The Constitution is what it is. All right. The next thing I want to talk about are the amendments to the Constitution. And the first article is Article 1 or Amendment 1. Congress shall make excuse me, no law respecting an establishment of religion. Excuse me while I wet my whistle here. Congress shall make no law respecting an establishment of religion. Two important components here. One is an establishment of religion or prohibiting the free exercise thereof. There are two very important components that play on each other: establishment and prohibiting the free exercise thereof. The next phrase is or abridging the freedom of speech or of the press. And the next and last component is the right of the people peaceably to assemble and to position the government for a redress of grievances. These are all Age of Enlightenment ideas. Me. Important thing to look at here, and it's going on today in our country, is that governments have prohibited the right of the people to assemble. Now, we all agree that it's for a good cause. It's certainly appropriate that the state legislatures and even local mayors and councils restrict our activity because of the pandemic of the COVID-19 virus. However, we reach a point, and we have reached that point in certain states, in North Carolina, for example, where the people are concerned about their rights to gather. In particular in North Carolina, the right to gather to worship. Now, we may all agree that it's not a good idea to gather in large numbers to worship. Other people don't share that idea, and they think they want to gather using social distancing or whatever to worship. And so some of these churches brought a case against the state of North Carolina, which was heard in the Eastern District of North Carolina in Raleigh just last week. And the judge said, you can't do that. You can no longer restrict people from worshiping. You can't prevent them from gathering together to worship. It's a violation of the First Amendment of the Constitution. And so this is a touchy issue. Unless Congress declares martial law and the President agrees and the Constitution and the Bill of Rights are suspended, as is habeas corpus, for example, it's touchy ground. It's touchy ground. The state can impose restrictions on places over which they issue licenses, like bars and liquor stores and certain things like that, and they can close these things off. But over time, if people push it, there's going to be a constitutional question that comes into play here. Just how much right does the state have, and how much right do the people have to assemble? But that'll all be worked out. And the beautiful thing about living in the United States is we're all bright, intelligent people who want to do the right thing. And we don't want to cause harm to our fellow citizens. We want to do the right thing, and we want to have this coronavirus stamped out by doing the right thing. And hopefully that's what will happen in all these cases. But still, there are legal issues, and there's a big legal issue right here. The Second Amendment to the Constitution states, slide, that well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, a lot of people think that the Second Amendment has to do with taking your gun to the firing range or hunting or that sort of thing. Well, at the time that this was passed, this particular amendment to the Constitution, it has nothing to do with any of those things. It has to do with the way it starts out with the words, a well-regulated militia. And it was intended that the people be armed to protect themselves from the government. Now, whether you like that idea or not is not really for me to say. A lot of people today want to tinker with it, and they say, well, this kind of weapon is legal, this kind of weapon is not legal. But then there again, once you start tinkering with that, you get into very delicate areas of the Second Amendment. Again, if you want to change the Second Amendment, if activists want to change the Second Amendment, I've described to you earlier how you can do that. But you can't tinker with the amendments. They are what they are, and they were written for the time that they were written. Third Amendment, which really doesn't apply to us anymore, has to do with quartering troops in our houses without the consent of the owner. But since I've lived here at River Landing, I haven't had a request from the North Carolina National Guard to quarter anybody in my home. But see, I did have somebody. Who was that? Homer. Homer wanted to come and spend some time with me, and I didn't let him do that. I didn't think it was a good idea. Anyway, Amendment 4, the right of the people. And this is a very, very important amendment that's been a little bit abused here lately, I think. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. The Fourth Amendment is a very, very important document, a very, very important amendment, because it describes particularly what should be done. And that it says clearly that the search warrant should be based on an affidavit. And what you see now is what the Federal Rules of Criminal Procedure have to say about an affidavit. And I want to read that to you. It says, the affidavit must meet the following requirements. It must be sworn and attested to by an investigative or law enforcement officer as defined in 18 United States Code Section 2510. Criminal Division policy requires that the affiant be a member of one of the following agencies, and it lists the FBI and others that can do that. Criminal Division policy precludes the use of multiple affiants except when it is indicated clearly which affiant swears to which part